Let's bring in in-session correspondent Gene Casares, civil attorney Anahita Sedaghatfar to talk about this. But real quick comment from Gene here. Gene, this judge, yesterday versus today. Yesterday, we noted he was not happy in that courtroom. Today, what?
On any other grounds.
Now, Anahita, tell me what you think about the judge's ruling here, because is it going far enough? Or do we still have a problem with this testimony and the jury hearing it?
Ryan, I think what happened was huge. Did I think a mistrial was going to be granted? No. I think the defense did the right thing. They were vigilant in preserving their objections, making their arguments in order to preserve that for appeal. But, you know, if I'm the defense attorney, I'm actually okay with the fact that there is no mistrial here. The defense clearly is you know, going, in the eyes of the judge, is doing pretty well, whereas the prosecution, they've been reprimanded twice now in 2 days. If you recall, the first day, within, 8 minutes of the prosecution's opening, they were reprimanded by the judge. The second day, the judge did not hold back at all in terms of what he felt the prosecution's tactics, you know, involved. And I think he even called it a low blow. So if I'm the defense attorney, I'm actually, in a way, glad that there is no mistrial, because certainly there would have never been a mistrial with prejudice. So if anything, the mistrial would have been without, and the prosecution would retry the case. But why give the prosecution a second bite at the apple here? They've made many mistakes. It would just give them an opportunity to cure those mistakes. If I'm the defense, I'm taking this, especially the judge's instruction, and I'm spinning it. I'm bringing it up in my closing, and I'm telling the jurors, look at how weak the prosecution believes their case is. They have no direct evidence, so they're basically just throwing out there any evidence, potential evidence, alleged evidence, facts, whatever, to see what sticks.
But Anahita, let me ask you this, though. Does a jury, in your experience, see some of this and say, hey, well, the prosecution's just trying to do what it wants to do here? Because I know there's the sense of, oh, you know what? The defense can step up and say, look at these prosecutors, they're overzealous. But what do so many people out there who want lawyers want out of their lawyers? They want them to do anything they can to get the result that they need.
Exactly. Anything they can, but not anything that's prohibited by the law, not anything that violates a prior court's order here. I mean, that's crossing the line. And yes, if I'm the defense attorney, I am taking that, and that is going to be one of the first statements I'm making in my closing, that look at how desperate. I mean, this screams desperation. And the jurors, look, the jurors, they take an oath. I believe jurors do the right thing. I believe the jurors listen to the jury instructions. They follow the law. We have to give them credit for that. But they're human beings. They see what's going on. And I can tell you this certainly does not look good for the prosecution. So as the defense attorneys in this case, I'm actually taking the judge's ruling and I'm using that to my benefit. I'm using that in my closing argument, and I'm using that once again to reinforce to the jurors how weak the prosecution's case really is here.
Yeah, you know, I think it's an interesting point. And I also wonder all the time with jurors, can you unring those bells once they're rung, as this one was in the courtroom? Gene Casares, Anahita, you know what I think is interesting, Anahita? So, and I agree with Gene. I think they're going to come up. They're going to continue to be aggressive. But, I wonder, you just mentioned the idea of, okay, this is going to be used against them in that defense close. They're going to talk about that overzealousness. So as they go forward, especially on this very critical issue, of course, the jury, they start arguing about hearsay. It'll be outside of the presence of the jury. As they go forward, what do you expect from them? Do you expect them to continue to be aggressive, knowing full well that, another smackdown by this judge could hurt even more?
Right. I definitely expect them to be aggressive. I expect them to, be advocates for the state. That's their job. But I would certainly also expect that they're going to tread a little bit more carefully, because they do not want another slip up like this, not only in the eyes of the judge. And believe me, I think the judge earlier stated that judges do keep internal scoreboards of the attorneys in these types of cases. Not only that, but this looks terrible in front of the jurors. The jurors, yes, they a lot of the arguments will be held outside of the presence of the jurors, but the jurors nevertheless get feelings for what's going on, and they can sense what the judge's feelings are towards the various attorneys in the case. So yes, are they going to be strong? Are they going to advocate for the state? Absolutely. But I think they're going to tread a little bit lighter, and they're going to try to be very, very cautious from here on out. They have to.
Oh, cautious. All right, we'll have to wait and see, because they haven't shown that caution so far. Then again, prosecutors, they want to be aggressive, so we'll have to see what happens. All right, folks, we're expecting them to begin the protesting stuff in a lot of different ways. Anahita, let's bring you in, because there's a couple different things here. I want to first ask you about him saying he has all this experience, and take you back to what we heard on direct with him still saying it took me 6 minutes or so to get in that door. Hey, maybe the defense uses this to say, as much as you think he might have locked the door and Drew Peterson might have done all this planning, it's a guy he's probably one of the best out there, and yet it still took him time to get in.
That certainly helps the defense, doesn't it? I think if I'm the defense on cross, I'm not going to attack this guy. Clearly, he seems to be sympathetic to Drew Peterson. But if I'm the defense, I'm going to ask him, isn't it true that you don't know Kathleen Savio? Isn't it true that you don't know what her custom and habit was with respect to locking or not locking her front door? Isn't it true that you don't know whether or not Kathleen Savio has another lock on her bedroom door? I mean, these are the things that if I was the defense attorney that I would try to elicit from this witness to show that this guy really knew nothing other than he was called to unlock, to break the lock and get inside to the house. He didn't observe anything. I would ask him that. Did you go into the house? No. Did you see anything? No. This witness is basically irrelevant for the prosecution and arguably for the defense, other than to say he really doesn't know anything, other than he was called to open the lock on Kathleen Savio's door.
What about the idea that Drew Peterson is there, he calls him up, he's known him for years, he lets him in the house, but he knows Drew Peterson, and perhaps the prosecution will try to build out this theory of, yeah, Drew Peterson set this thing up, and he's calling people and talking to people that he knows won't mess with the situation around this house. We'll essentially be able to sort of backstop the theory that this was all a setup, so Drew locks the door and then calls a guy he knows will just come, do the job, and take right off.
Right, that's certainly an argument that I expect the prosecution to make. Is it a good one? Not really. It's a small town. This guy clearly has a lot of experience. He's testifying as to his experience, his expertise. He's arguably the best in the business. That's the position I would take as the defense. But absolutely, the prosecution's going to try to, again, use anything that it can to bolster its claims here that Drew Peterson committed murder, even if it means calling the locksmith and trying to somehow get the locksmith to persuade the jurors that Drew Peterson committed this murder.
Okay. Now, Gene, I understand you have another update. And maybe that's what the jury would want to see from him as well. Anahita, so we know where this locksmith is going. I know that you don't put a lot of credence into him except that he was there, opened the lock, and took off. But talk to me about this door situation. And I'm asking this because the theory is going to be that Drew Peterson knows this house, that it's a bolt lock. He goes in, shuts that bolt lock door. The locksmith comes there and says, oh, the bolt's really easy to open. So maybe Drew Peterson's just concerned about closing that door, getting right out and calling the locksmith. See, these are all things that the prosecution can say, or at least can try to build into, but are you hearing enough support for that?
Of course the prosecution can say these things, Ryan. Of course they are going to say these things. In fact, this is probably why they called this locksmith to testify. But at the end of the day, how much weight is that going to carry? Where is the DNA evidence? Where are the fingerprints? How did Drew Peterson exit the home? Presuming he got in through the front door and was able to pick the lock, how did he exit? And where are the forensic pieces of evidence here? That is what the defense needs to focus on. If Drew Peterson concocted this entire scheme, and like I said before, the prosecution needs to figure out how they want to paint Drew Peterson. Either he's a smart guy who pulled off a crime, or he's not a smart guy, and it just does not make sense. I think the prosecution is confused here.
Okay. All right, Anahita, Gene, stand with us. Folks, let's take a quick break. We'll come back with more updates. Court is in session as we job. Now, Anahita, you talked about how you would question this witness a little bit earlier. They're trying to cover a couple different bases in cross-examination. How much further would you go with this?
I wouldn't spend too much time as the defense attorney on this witness. Again, the main testimony that I would want to elicit from this guy is, do you know Kathleen Savio's habits, custom and habits with respect to locking or not locking the door? No. Do you know whether Kathleen Savio had a lock upstairs in her bedroom? No. These are the things that are going to be relevant. These are the things the jurors are going to want to hear from this guy. Other than that, I wouldn't push too far in terms of cross-examining him. Look, it's natural for a witness to take the stand and forget things that happened, years ago. That's why we have the ability as attorneys to refresh the witness's recollection. I mean, I have to do that all the time in my trials, especially when there is, many years have passed from the date of the alleged incident or the date of the testimony to the date they're testifying in trial. So I don't find that highly unusual, and so I think that this is a pretty common thing.
All right. Anahita Sedaghatfar, thank you so much. Gene Casares, thanks as well.
Thank you.
Thanks to all of our other guests. Of course, Judge